we are of the view that such a right should not be granted.
Hi guys, how are you guys doing? Welcome to the channel. The tribunal did not grant permission to Ms. Mengo's legal representatives to cross-examine the witnesses, JP's witnesses and JP as a respondent. Remember, earlier on, they put forth their application to be granted permission to cross-examine JP and to also cross-examine JP's witnesses. So the tribunal panel decided not to grant that permission based on the act. The judge explained the act very well, that only the respondent can cross-examine, but not the complainant. So the judge explained the act very well, and then I'll give you a chance to listen to the judge's explanation. Ms. Mengo's legal reps argued that in terms of fairness, they were asking permission to be granted to them to cross-examine as well, for fairness sake to all the parties involved. They also argued that they are also doing that to help the tribunal to come to the right conclusion. But unfortunately, according to the Act, they are not allowed to cross-examine the respondent and the respondent's witnesses. So, the Act only gives the right to the respondent, not the complainant. Hence, the panel decided not to grant permission to Ms. Mengo's legal team. Also, according to the Act, the complainant, which is Ms. Mengo in this case, she was not even supposed to have a legal representative. That's according to the Act. But the chair explained that they allowed her to have the legal rep only because they wanted the process to be fair. But the Act does not stipulate that. So for Ms. Mengo's legal reps to go an extra mile now and asking permission to be granted to them to cross-examine, according to the chair, they are now going too far. So they have already bended the rules by allowing Ms. Mengo to have legal representative. So it will be too much now if they will be granted another permission now to cross-examine. That will be too much bending of the Act. So the chair did not grant permission for them to cross-examine the respondent and his witnesses. Let's listen to the chair and tell me what are your thoughts on the comment section. Do not forget to subscribe, like and share, and I'll see you on the next one.
I think we're resuming to hear the application by Advocate Butland on behalf of the complainant with regards to their quest to cross-examine the complainant as well as witnesses called in at the instance of the complainant. I think that is where we are. Mrs. Butland.
Thank you, Chair. Chair, you would have received our affidavit filed overnight and the one filed on behalf of the respondent this morning. We've set out in our application the basis for what we seek, which is a right to cross-examine the respondent and any witnesses called on his behalf. And we seek the permission of the tribunal to do so because we recognize that it is not a right that we have under the Act or the rules. It is correct that the Act creates no positive right for the complainant to be represented in these proceedings, but the Act also does not preclude the panel from permitting the complainant to have legal representation, or indeed from permitting her legal representatives to be able to do any cross-examination. In fact, our presence here, my and my attorney's presence here through these proceedings, is something that we do by virtue of permission of the panel. It's not something that we have a right under the Act to do. Now, the respondents in their affidavit responding to our application say that they agree on that factually in the statute and in the rules, but that we misunderstand the Act, they say, and we misunderstand the Act because Section 26(4) of the Act says that subject to this Act, a tribunal has the power to regulate and protect its own processes, and their interpretation of that is that it does not entitle the panel to do something which is not provided for, which is beyond the scope of the Act. That's how I understand the argument, but Mr. Skakani will correct me if I'm wrong. We disagree. We consider that the language in Section 26(4) is not unusual language as statutes go. In fact, it's even language that's referred to in the Constitution, and I'll come to that shortly. The fact that this tribunal is entitled to, subject to the Act, regulate and protect its own processes is, first of all, confirmed in the terms of reference as a starting point that are dated 20 March 2024, and that's at volume 4, page 324 of the tribunal bundle. So what does this power mean, to regulate and protect your process? Let me say this first. The tribunal has already made a decision at the outset of these proceedings to allow the complainant's legal representatives to participate in these proceedings. That decision was a limited one, which was to question and ask questions of the evidence leaders' witnesses. And we're grateful for that opportunity to be able to do that, and we hope that that's been of assistance to the panel. Now, I would submit that perhaps one of the reasons that the panel permitted this was an acknowledgement of fairness that's required in this process. And the concept of fairness in a process, not entirely dissimilar to this, was dealt with in the Constitutional Court in a case called Mawande Makala versus DPP Western Cape, and that's 2025, Volume 4, BCLR 399, Constitutional Court. Now, this case was, albeit in a different context, it was in a criminal context, and it had to do with extracurrial statements. But what's relevant is that the court had to interpret a similar phase about being entitled to give effect, to protect and regulate its own process. And what's important is in that case, the Constitutional Court prioritized fairness and the obligation to interpret laws in line with the Constitution. So in that case, the court emphasized that requiring or ensuring fairness in the procedures in that case of a criminal trial meant considering the rights of the accused, the ability of the prosecution to perform their duties, and importantly, the interests of society in ensuring that the truth can be ascertained. In respect of our courts, the power on superior courts to regulate their own process is contained in Section 173 of the Constitution, in which this panel will know has been relied on extensively by our courts, often where there's a vacuum in legislation or a vacuum in the procedure that's relevant. And there are many cases in which the Constitutional Court has referred to that. The early cases, which I'll just refer to, S versus Pennington and another, that's 1997 4SA 1076, and Parabu and other versus Getz, 1997 4SA 1095. And those cases essentially look at what are proceedings, what is procedural law, what is the meaning of Section 173. What's important to note is that the wording in Section 25(4) that's before this panel is almost identical to the wording of Section 173 of the Constitution. And 173 of the Constitution has been used in matters of evidence, which are commonly understood as procedural matters, similar to what this tribunal will have to deal with, and in cases where the legislation is silent on a specific procedural question. So we would submit that the question of a court having a right to regulate its own process is broader than what the respondents contend for, that it would have no meaning if you were bound strictly by the terms of the statute, because you have an obligation to interpret statutes in line with the Constitution, and one must do so also being aware and cognizant of the obligation to fairness to all parties concerned. So what should this panel be guided by? Well, we referred in our application, our affidavit, to the Judicial Conduct Tribunal ruling in the Hlope matter. We accept that that's not binding on this tribunal, but it may give some guidance on how a tribunal approaches and interprets its powers in a not dissimilar process. And in that case, you'll see we've quoted extensively from the case in our application, but it was submitted on behalf of Judge Hlope that the complainants in that matter, who were the justices of the Constitutional, several justices of the Constitutional Court, were not entitled to participate in the tribunal through their legal representatives and to make closing arguments. The tribunal in that case ruled that there was simply no merit in that submission. They also said that the tribunal proceedings are sui generis. They're not akin to criminal proceedings. and that unlike criminal proceedings, they are inquisitorial. The fact that the tribunal is inquisitorial is clear from Section 26.2 of the JSC Act. And to be inquisitorial, we submit, means really a truth and fact-finding exercise that places more of an emphasis on the role of the adjudicators than would be the case in an adversarial system. So anything that's going to assist this panel in performing its inquisitorial task would be relevant to a consideration of how to regulate this process, we submit. Coming back to the Hlophe Tribunal, that tribunal found in its ruling that the participation of counsel for the justices was necessary and was permitted, and that the suggestion that the participation of counsel for the Constitutional Court justices, the suggestion that that participation prejudiced Judge Hlophe, I quote, as merely to be stated to be rejected. Now, in that case, of course, it was a little different because in the Hlophe matter, the issue of the participation of representation for the complainants came quite some time after the complainants had been represented. And the ruling makes that point. It said that this has been the case since 2009. So there had been a practice, and perhaps we're not entirely identical to that in the sense that we don't have a practice. It wasn't clear from the outset that I would be entitled to cross-examine the respondent's witness. But we do have a practice of permitting the complainant legal representation in these proceedings. And we do have a practice that our role is not that of the evidence leader, that is there to clarify and to ask questions that are sought to protect the complainant. That's the role. So we would submit that your discretion ought to be exercised in favor of permitting us to continue to cross-examine and to cross-examine the respondent and any witnesses brought on his behalf, as we have done throughout these proceedings. We would also submit, to the extent that this tribunal is going to consider whether or not we have a right to make oral and written submissions at the end of these proceedings, we would ask that we be entitled to do that. And we do so really in an attempt not just to represent the complainant, but to assist the tribunal in its task. So in light of all of this, we respectfully submit that the tribunal ought to exercise its discretion to permit us the right to cross-examine and to make oral and written submissions in due course. And we submit there's no good reason to move from that, from the position that the tribunal has already adopted in relation to us. In fact, it's notable that in the respondent's response, they don't provide a good reason or any reason why we shouldn't be permitted to do so other than that we don't have a right under the statute to participate. And our response, quite frankly, to that is the fact that you don't have a positive right doesn't necessarily mean that what's more important is there's no provision in the Act that precludes us from participating. So we would submit that is important, and that must be factored into the exercise of the discretion that the tribunal has to undertake. Thank you.
Before Mr. Sikakane comes in, let's just point out some of the problems that may arise if we were to do that. We are aware that we have the power to regulate our own procedure, but that power must be exercised, as indeed we felt we did, must be exercised with a purpose, and the purpose is to ensure some fairness, which is why, right at the beginning, we allowed legal representation for the complainant, and also allowed you to put questions to the complainant and complainant witnesses. But here is this difficulty. Let's start with the Act itself. The Act says only the respondent is entitled to legal representation in these proceedings. It does not give the right for legal representation to the complainant. It doesn't. And that does not look like it's an omission. It is an exclusion. It's not accidental. The Act is very clear. It was aware that there would be a complainant, but then the Act decided to give the right to legal representation only to the respondent and stop there. It didn't give the right to the complainant, for whatever reason. Not only that, consistent with that come the rules which were made under that Act, which does not give the complainant the right to legal representation. Consistent with that comes the rules. The rules say the leader of evidence can cross-examine. The respondent can also cross-examine. Again, the rules do not give the complainant the right to cross-examine. That the rule doesn't. And you can see that that rule is entirely consistent with the Act, because the Act doesn't give the complainant the right to legal representation. And then further, when you come down to the rules also don't give the complainant the right to cross-examine. They are in sync. Now, when you ask us to exercise our authority in regulating our own procedure, do you think it would be appropriate for us to use that privilege, that right which the Act gives us, to then go and do things which the Act excluded and the regulations excluded? Do you think we should do that?
Thank you, Chair. So I think the starting point must be the Act does not specifically preclude the complainant from being represented. It does not say anything about it. And I can't differ
the
from
Act
you.
doesn't say nobody must matter anybody. You can't even matter anybody. The Act doesn't.
Fair enough.
The Act enables you. Then you can't say because the Act excludes 1 million things, those 1 million things can be done because they're not prohibited under the Act.
Yes.
When you look for power and authority, you go to the enabling instrument as to what it gives, not what it doesn't, what it excludes, because it excludes everything in the world.
Yes, but it's not, the example of murder is of course an extreme one, but we are dealing here with complainants, right? And one anticipates, and I hope the legislature had anticipated, that there will be different kinds of complainants. So often in these proceedings, for example, the complainant is a judge president, because there may be, and there have been many instances in which there are complaints against judges, for example, for not delivering judgments on time. There the complainant would be the judge president, but he or she is not actively representing themselves and their own position. They are simply bringing a complaint that has been made to them to this forum because it relates to a judge in their division. That is a very different kind of a complainant, and one can see why there that judge president doesn't require legal representation. In that situation, the evidence leader obtains the evidence and presents it, and the judge president is not an active complainant. This, I would submit, is a different kind of a case, and I accept that there are not many of these kinds of cases, and so what we're asking of the panel is for you to go a little further than perhaps has been done. But it would not be that this tribunal is the first to do so. In the Hlope matter, complainants were justices of the Constitutional Court. They were represented by a senior counsel, and they were represented throughout the proceedings. They cross-examined all of the witnesses, and that was permitted. So for you to do that wouldn't be the first time that it's done. That's the first thing. And that ruling is not a 1 or 2 paragraph ruling. It's a comprehensive ruling. It considers this question specifically under its own heading, and it resolves that the complainants were entitled to legal representation, and does so under both inquisitorial power as well as the power to regulate its own process. So we would submit that while it may seem that what we're asking from this panel is extreme, it's really not extreme. It's asking this panel to take into account that this is an inquisitorial process that requires you to be different to a judge sitting in a high court, number one, and really to do a fact-finding and truth-finding exercise here. How best you achieve that is part of that decision of how you regulate your process. In this case, you have a complainant who is someone who you can see hopefully through our engagements that our engagements were required to put issues to witnesses that the evidence leader did not. And so hopefully that shows that participation is of assistance to the tribunal. And I think that's relevant, a factor that you must consider. I don't think that you are precluded. I would submit that you're not precluded from permitting legal representation, and that in fact, to the extent that you were to write a ruling on this, you could even be clear that it is not in every situation that you think it would be appropriate for a complainant to have legal representation. But in this situation, there are circumstances which justify it and would assist the tribunal. So I'm not sure, Chair, if I've answered your question, but I think both the nature of this particular panel, as well as the fact that the Act doesn't specifically preclude you from doing this, should be factors that you take into account in what is an exercise of a discretion.
You referred to us, to the one tribunal. Is that the Hlope tribunal? Yes. We have read their ruling. But what is singularly missing in that ruling is how they went about the exclusions in the Act and all of the rules. In fact, there's no reference even to the rules whatsoever. So you read it, you don't find any breach that carries you over that problem because there's absolutely no reference to the rules. So that is one difficulty. But in the spirit of wrestling openly and frankly with this thing, let us also tell you that we spoke to one of the judges who I first tried to phone the Judge Labuskakhe, who was the president of the tribunal. I couldn't get hold of him. Then I was able to speak to Judge Makhuka, who was one of the members of the tribunal. Indeed, he confirmed that they allowed cross-examination in that case because in the ruling itself it's not clear, but he says they did allow. Then we spoke to Judge Jafta, who was presiding over another judicial tribunal. And he said that the cross-examination was not done in that case. But although he did indicate that the issue didn't arise, but it was not done. Then we also spoke to Judge Japi. He presided in another judicial tribunal. And he said the cross-examination was not done in that case. And he then went on, we don't have to go into those reasons, they may be debatable, but he indicated that he would not have allowed cross-examination. And he mentioned a reason which is arguable, which can be arguable, which doesn't bind us at all. So those are the scenarios that we have. Now, let me come back. You said each case must be considered on its merits. Let me come back to this particular case. And in the exercise of our discretion, in the exercise of our power to conduct our own proceedings, we were very much allowed and influenced by the very point that you are making. And we tried to sail as close as possible to the Act, which says nothing, and to the rules, which also say nothing. We tried to sail as close to them as possible. But we were a bit hesitant in violating them, going against them. But we tried to sail as close to them as possible. You know what we did. You know what we did in this case. We said, we said, in all fairness, although the Act does not provide for legal representation by the complainant, we decided that we are going to allow it, and we allowed it. Indeed, we even allowed you to ask questions. And in one of the discussions we had with one of the presiding judicial officers, he was clear that the complainant must, if she has got any, or he has got any issues, must speak to the leader of evidence. The leader of evidence would put those points across. But in this particular case, I think we went a little bit further there. We allowed legal representation, and we allowed you to put questions. And not only did we do that, we have already indicated to you that we are going to allow you to make written submissions. We even gave you a date. So you can see that there is an attempt on us, while the Act and the like are like, don't provide for that. You can see that we've been very mindful of ensuring that there's fairness. We went some distance, and then in the manner that I've explained, to allow legal representation, which is not provided for. We allowed you to ask questions, and we are even going to allow you to make written submissions on our behalf. That's what we've tried our best to do. Now, you want a lot more now. And that a lot more now that you want is what I was saying to you, that it now brings us into direct conflict with the Act. We wish we could just find it easy to resolve that, but I think I'm mentioning the steps that we allowed you to participate in because we want to indicate to you that we're very much alive to the issue of fairness. But we are not the legislature. We didn't make the law, we didn't make the rules. And I'm going to mention this because I want Mr. Singulani, when he makes submissions, says
Time I'm suing.
Mr. Sikakari, I think I'll refer to Mr. Madam Sela from now henceforth, but you must know I'm referring to you. In the event and we're not prejudging, but we're just saying, in the event we don't allow you to cross-examine the witnesses, the respondent, the witnesses, we are wondering whether, as a further attempt on our part to ensure fairness without violating the law, we would say that, yes, the leader of evidence will cross-examine, but you would have the right to consult, you and the complainant will have the right, before the evidence leader comes to put questions, you have the right to consult with the evidence leader, raise whatever issues you want the evidence leader to raise, and if need be, if we have to adjourn proceedings for that kind of consultation, subject to what Mr. Sikakan will do, I will subject to how they will react. We would even be prepared to adjourn after every such witness, including the respondent, even adjourn to allow you to speak to the little evidence as to what issues you feel that she should canvass. It will be up to her, of course, to decide whether she wants to canvass this or not. I'm disclosing in advance all these things because, as I said, we would like you to get a full picture as to how we intend to bring about fairness without violating the Act and the rules. Yes.
Thank you. Let me start by saying we are very grateful to this panel for permitting us our participation thus far. One of the concerns, I said this on the first day, one of the concerns that the Women's Legal Centre had, which brought us into the case, was how complainants navigate this process. So this is not just a question for us in the abstract, it's a very real question. So we do appreciate the panel taking the time to really carefully evaluate what it is entitled to do and not to. Our submissions, you have our submissions on how you should exercise your discretion. I'm not going to repeat that. I think that if this panel decides not to permit us to cross-examine, then the suggestions that the chair makes to me about permitting us to consult properly with the evidence leader would be important, and we would appreciate that. Part of our difficulty has been the criticisms of our role and our relationship to the evidence leader, so we've tried very carefully to keep some measure of distance. But if we have a clear ruling that that is permitted, that we're able to consult with the evidence leader before she cross-examines, and to raise things, of course she would have to do that with the complainant anyway to get information instructions. But if we have the permission that we're entitled to do that, we would appreciate that, and we would think that that would certainly assist. Of course, we are at the mercy of the evidence leader. She will decide what she wants to ask and what she doesn't want. So we're not. It's not certainly not a perfect position from our perspective, but we understand where the panel is coming from. We still stand by our submissions that the panel is entitled to permit cross-examination. Thank you.
Thank you.